Well, Donald Trump's childish fantasy about what the presidency is could now destroy the careers of people who share that fantasy. Just before midnight on Friday, Donald Trump proved once again that he thinks that the title President of the United States comes with powers that only exist in fiction, lightweight fiction, that include, say, Bond villains who issue orders to destroy the world if anything happens to them. Donald Trump actually wrote at 11:18 p.m. on Friday, 1,000 missiles are locked and loaded and aimed at the Islamic Republic of Iran, with thousands of more to immediately follow, should the Iranian government act on its threat pronounced in many corners of the globe to assassinate or attempt to assassinate the sitting president of the United States of America, in this case, me, exclamation point. Orders have already been given, and the U.S. military is ready, willing, and able for a one-year period of time, subject to extension, to completely decimate and destroy all areas of Iran. That Trump composition is overflowing with more than one variety of madness, but for the moment, let's just consider the constitutional madness. Dead presidents don't bomb. Donald Trump actually thinks that orders given by a dead president are something that, quote, the U.S. military is ready, willing, and able to do. The next time any general testifies to Congress, that general should be asked if the United States military is ready to carry out the destruction of Iran for Donald Trump if Donald Trump is assassinated. That general might very well be fired if that general testifies that, of course, the military doesn't take orders from dead presidents, and that only the new president, in this scenario, J.D. Vance, could order a military attack on Iran. Donald Trump obviously doesn't know that. I mean, he really doesn't know that. It's not the first time Donald Trump has said this crazy after-death threat. On February 4th, 2025, the New York Times reporter David Sanger ran a story under the headline, Trump says he left instructions to obliterate Iran if it assassinates him. The Times article included this line. In fact, experts say a president cannot leave instructions for military action after his death. That decision would have to be made by his successor, who would then be commander-in-chief. Yes, experts say that, as do high school students and anyone else who has the vaguest idea of what the presidency and vice president are and how they work. Here's the really, really crazy thing about the state of the White House press corps. In the year and a half since February 4th, 2025, when Donald Trump first said he left instructions to obliterate Iran if he is assassinated, not one White House reporter and not one reporter anywhere else with access to J.D. Vance has ever asked the vice president if he has been given that order by Donald Trump and if he intends to follow that order if he becomes president in the scenario Donald Trump imagines. And since Friday night at midnight, no reporter has made any attempt to ask J.D. Vance about Donald Trump saying orders have already been given and the U.S. military is ready, willing, and able to completely decimate and destroy all areas of Iran. Will J.D. Vance give the order to kill everyone in Iran? That's the kind of thing that the formerly serious Hugh Hewitt would have asked Donald Trump years ago, before Hugh Hewitt decided to become a Trump cheerleader. In a live interview with Donald Trump today, this is the only thing Hugh Hewitt or Donald Trump said about J.D. Vance.
Now, if the Democrats win the House, they're going to impeach you. And I don't care what the argument is. They're just going to find a way to impeach you. You know, J.D. Vance could represent you, and he can be in the Senate doing the same thing. Have you thought about that? He's a good lawyer.
Well, I don't like to think about it too much because I think we're going to do well.
He's a good lawyer who has never tried a case, never defended a client in a courtroom anywhere. There are two reasons why the White House press corps has never asked J.D. Vance whether he will follow Donald Trump's orders after Donald Trump is gone. One is the intellectual laziness too many of them bring to their job. And the other thing is, and this is the biggest part of it, I guess, no one believes Donald Trump. No one in the world believes Donald Trump about this. No one in Iran believes that the president of the United States can leave orders that then get executed after he's gone. Because everyone in the world who needs to know about these things, very much including the regime in Iran, knows that the Constitution does not allow dead presidents to bomb anyone. That power would not belong to Donald Trump in the scenario that he presents. It would belong to the new president, J.D. Vance. The whole world knows that. But Donald Trump's utter immunity to personal humiliation allows him to publicly issue this utterly empty, completely frivolous, and morally repugnant threat that reeks of constitutional illiteracy. But Donald Trump's immunity to humiliation does not extend to those who choose to serve him. Just ask this guy, the now disbarred lawyer Rudolph Giuliani, former mayor of New York, former federal prosecutor, current disgraced clown. None of the Trump lawyers have been disbarred yet, like Rudolph Giuliani. None of them in his second term have been disbarred. But a federal judge today raised that possibility, and in the process made Donald Trump's nominee for Attorney General Todd Blanche the first nominee for Attorney General in history to be referred by a federal judge for possible investigation by the Bar Association in the state of New York, where Todd Blanche is licensed to practice law. Federal Judge Kathleen Williams, who was appointed by President Obama, crushed Donald Trump's constitutional fantasy today, and Todd Blanche's fantasy that he can legally behave as a lawyer any way Donald Trump orders him to behave. By doing Donald Trump's bidding, which the judge found was not legal, Todd Blanche has now been sanctioned, along with other Trump lawyers in the case. But only Todd Blanche is 2 days away from a Senate confirmation hearing to become the next Attorney General of the United States. The historic 56-page decision reveals Donald Trump and Todd Blanche's legal madness in exacting detail, and it reminds American voters what is at stake in their votes for United States Senate, the place where federal judges are confirmed. Maine voters already seem aware of that importance, with Republican Senator Susan Collins' re-election campaign in trouble, specifically because of how she votes in Senate confirmations for federal judges, including Supreme Court justices. The judge's ruling in this case came in a court case titled President Donald J. Trump versus Internal Revenue Service. The question before the judge was simply, was it a real case? Or was it a fake lawsuit brought by Donald Trump against himself, since Donald Trump is in control of the Internal Revenue Service and the United States Treasury, the two defendants Donald Trump was suing? As you heard from legal commentators on this program, including Andrew Weissman, a lawsuit has to actually involve what a court calls adverse litigants, meaning the two parties actually have to be opposed to each other. Andrew has pointed that out repeatedly about this lawsuit. The judge determined today that this lawsuit did not actually involve two sides, but was really Donald Trump just suing himself. And in her 56 pages of dismantling the Trump fake lawsuit piece by piece, Judge Williams patiently waited until page 43, just exquisite work as a dramatist, page 43, to use the smoking gun given to her by the stupidest litigant in history to ever sue himself.
I'm sort of suing myself. I don't know. How do you settle the lawsuit? I'll say, give me X dollars, right?
Right. And so, on page 43, the judge writes, certainly a court should not be a forum for a party that cynically views a lawsuit as a vehicle to achieve a predetermined outcome. I'm suing myself. Quoting Donald Trump there from that appearance. In the rare cases where judges are forced to figure out whether the parties are really adverse to each other in a lawsuit, they pretty much never have the plaintiff in the lawsuits saying publicly on television, I'm suing myself. That is Donald Trump's unique contribution to the history of this kind of case. And yet another demonstration at the same time of the reason why careful litigants never say anything publicly about their cases. And the stupider the litigant is, the more dangerous it is to say anything publicly about their cases. The judge found that the lawyers on both sides of the case abused judicial process in order to set up a structure in which Donald Trump could be granted a generous settlement by his own Justice Department in a case that was fake to begin with. It was a way for the Trump government to give Donald Trump $10 billion. Donald Trump sued the Internal Revenue Service and the Treasury for $10 billion because a contractor for the IRS released portions of Donald Trump's tax returns to the news media several years ago. Even though Donald Trump filed the lawsuit after the statute of limitations had passed, the Justice Department that he controls did not object in court to a lawsuit being filed after the statute of limitations had passed, something the Justice Department has done in all similar lawsuits. The judge called the lawsuit performative litigation. Judge Williams carefully grounded her findings in Supreme Court cases written by Donald Trump's allies on the Supreme Court, including recent Supreme Court cases, affirming the Republican legal position that every person working in the executive branch is under the direct control of the President of the United States and therefore acting for the President of the United States. The judge quoted a Supreme Court opinion issued just last month saying Article 2 requires that the president control all executive power, especially the authority wielded by agency heads who are the most important of the president's subordinates and who must be the president's alter egos in their agencies. The judge said Donald Trump was suing his alter ego, Treasury Secretary Scott Bessent, and that the case was settled by his other alter ego in the case, Acting Attorney General Todd Blanche, who previously served as Donald Trump's criminal defense lawyer, which left him, Blanche, in a decision-making position reeking of conflict of interest in this case. The judge's opinion implicitly turned on the assumption of abject and absolute cowardice on the part of Scott Bessent and Todd Blanche. The judge wrote, Secretary Bessent in particular is subject to President Trump's actual and direct control in both of his representative roles. First, as Secretary of the Treasury Department, Bessent is a member of the President Trump's cabinet. In this role, Secretary Bessent is the president's alter ego in the matters of the Treasury Department. Second, President Trump's actual control over Secretary Bessent is grounded in statute. The Internal Revenue Code establishes that the Department of the Treasury, a commissioner of Internal Revenue, shall be appointed by the president. The Internal Revenue Code also provides that Bessent, in his role as acting IRS commissioner, may be removed at the will of the president. The judge wrote essentially the same thing about Todd Blanche being Donald Trump's alter ego at the Justice Department and instantly removable by Donald Trump. But what the judge left out entirely is that we have had cabinet members in this country who do not live as cowards in the cabinet, as all Trump cabinet members do every single day. When Republican President Richard Nixon gave Republican Attorney General Elliot Richardson a technically legal order to fire the special prosecutor investigating President Nixon, Attorney General Richardson refused to carry out that order. Attorney General Richardson did not break in cowardice under an order issued by a criminal president. Instead, Elliot Richardson did something that Scott Bessent and Todd Blanche could never do. They could never, ever have the courage to do it. Elliot Richardson drew a moral line. Attorney General Richardson said no to the President of the United States, and he resigned. And the next person in the Justice Department, Richard Nixon, tried to get to carry out that order also refused and resigned. And because there was a time in our government then when honor came first. Among Republicans, honor came first. Elliot Richardson was a proud lifetime Republican. The third member of the Justice Department who Richard Nixon ordered to fire the special prosecutor did exactly what the president wanted, very obediently, and that decision came to follow Robert Bork for the rest of his life. When President Ronald Reagan nominated Robert Bork to the United States Supreme Court, 58 senators voted against Robert Bork, including 6 Republicans. Robert Bork discovered the hard way that in those days, there was no future in dishonor. Elliot Richardson set a standard that no one in the Trump regime would ever consider even trying to live up to. And Judge Williams knows that. And so she correctly assumes that defendant Scott Bessent in this case is under complete control of Donald Trump every minute of the case and every minute of his life. The judge can see what everyone in America can see when the Trump cabinet is gathered on TV to publicly worship him. Every member of the Trump cabinet was chosen for their flawless cowardice. And the judge made the point that Justice Department lawyers who were supposed to be defending the Treasury and the Internal Revenue Service in the lawsuit were also under the complete control of Donald Trump in the case. So Donald Trump was really suing himself, which is illegal. He tried to get $10 billion for himself by suing himself. Donald Trump's lawsuit asked Donald Trump's Treasury Secretary for $10 billion of taxpayer money to give to Donald Trump. And there was no attempt to change the terms of that lawsuit while it was suffering for weeks under constant public attack for trying to give Donald Trump $10 billion. Even Republicans in Congress refused to defend Donald Trump's attempt to simply seize $10 billion for himself from the United States Treasury. But the lawsuit eventually became politically untenable, and that is when Todd Blanche took it upon himself for everyone involved in the case to simply end the lawsuit and create a $1.776 billion fund, not to pay Donald Trump and his family, but to pay the people who attacked the Capitol to try to help Donald Trump overturn the results of the 2020 presidential election, to pay them all for all the suffering that they endured as a result of being prosecuted for trying to beat police officers to death and threatening to kill the Vice President of the United States. The so-called settlement was signed only by Todd Blanche. No lawyer representing Donald Trump as the plaintiff in the case dared to even put his name on that so-called settlement document. On page 36, Judge Williams said, Acting Attorney General Blanche's apparent capacity to speak for both plaintiffs and defendants signed a settlement document on behalf of all parties to this action and then repudiate part of that agreement demonstrates that there was only one party whose interests were being represented throughout the case. Todd Blanche eventually announced that the $1.776 billion fund would not happen. No one would get paid. The judge wrote, the court finds that this matter was brought for an improper purpose to gain the imprimatur of judicial legitimacy for a settlement that had no viable basis in law or fact. As was observed in another matter brought in this district, this case is part of Mr. Trump's pattern of misusing the courts to serve political purposes. The judge then sanctioned the lawyer who filed the lawsuit, quoting a Supreme Court ruling that said, the filing of complaints, papers, or other motions without taking the necessary care in their preparation is a separate abuse of the judicial system subject to separate sanction. Baseless filing puts the machinery of justice in motion, burdening courts and individuals alike with needless expense and delay. Even if the careless litigant quickly dismisses the action, the harm triggering Rule 11's concerns has already occurred. Donald Trump's lawyers dismissed the case in order to try to pull it away from this judge's jurisdiction and inspection of the case. The judge quoted the Supreme Court saying if a litigant could purge his violation of Rule 11 merely by taking a dismissal, he would lose all incentive to stop, think, and investigate more carefully before serving and filing papers. And the judge wrote, plaintiff's attorney, Alejandro Brito, is referred to the Florida Bar for its consideration, review, and determination as to whether any disciplinary action is appropriate in light of the findings and rulings made in this order. The judge barred Trump lawyer Daniel Z. Epstein from seeking admission to practice law in the Southern District of Florida. And the judge said the parties are prohibited from referring to the purported settlement agreement or using, offering, admitting, or citing any of its provisions in any judicial, administrative, regulatory, arbitration, or any other official proceeding as evidence of a settlement reached in this matter. Finally, the clerk of court is directed to mail a copy of this order to the State Bar of New York, of which Acting Attorney General Blanche is a member, and to the District of Columbia Bar, of which Associate Attorney General Stanley Woodward is a member, where disciplinary proceedings are currently ongoing. Judge Williams said that the Trump lawyers acted in bad faith on both sides of the case. She wrote, "Bad faith is present if a court determines that fraud has been practiced upon it, or that the very temple of justice has been defiled." Donald Trump has defiled Washington for years now in more ways than we can count, including recently defiling the very structure of the White House by swinging a wrecking ball at the historic East Wing of the White House, by defiling the reflecting pool. In the face of so much of the wreckage Donald Trump has visited upon Washington, the law has been powerless. But not today. Not today. Today, Judge Kathleen Williams said what no Trump cabinet member could ever say to Donald Trump. Judge Williams said no. And so this time Donald Trump lost in court in every possible way he could lose in court today. And this time, Donald Trump and his cowardly Treasury Secretary and his now sanctioned lawyers, this time will not be allowed to defile the very temple of justice. Andrew Weissmann joins us after this break. In her opinion and order today, Judge Kathleen Williams wrote, quote, "Whether executive branch actors can privately agree to give themselves and their former clients blanket immunities and billions of dollars in tax monies for legally undefined grievances was never an issue advanced to this court. The question is whether the parties could do so by claiming to be adverse and engaging the legitimacy of a court proceeding. The answer is a resounding no." Leading off our discussion tonight is Andrew Weissmann, former FBI general counsel and an MS Now legal analyst. He's author of the best-selling book, Liar's Kingdom, How to Stop Trump's Deceit and Save America. Andrew, you told us from the start in this case, it did not appear to have adverse parties in the case. That is exactly what the judge found today. What stands out to you in what the judge wrote today?
So this is what stands out to me. It is remarkable enough that on a Monday, we have a federal judge saying that the sitting acting attorney general, who has a confirmation hearing coming up in 2 days, has engaged in a bad faith sham litigation. But let me just dispassionately put that in context. In the Abrego Garcia case, a federal judge found that the Department of Justice and Todd Blanche specifically engaged in vindictive prosecution, and that criminal case was thrown out. When Todd Blanche and the Department of Justice sought to issue a grand jury subpoena to the Federal Reserve in connection with the sham investigation of Jerome Powell, another federal judge said that was in bad faith, and it was rejected. When a grand jury subpoena was issued in connection with an investigation of alleged election fraud in Georgia, this was just last week, a federal judge appointed by Donald Trump in his first term, rejected it and said it was bad faith and a sham. That is, again, at the feet of Todd Blanche. When a grand jury subpoena was issued and an investigation was launched by Todd Blanche into the sitting governor of Minnesota and the sitting mayor of Minneapolis, it was rejected as bad faith. Those are just some of the examples. We haven't even started talking about his cover-up in connection with Epstein. We haven't talked about his obstructing the state investigation of Alex Preddy and Renee Good. You could go on and on. What is remarkable about this most recent decision is how much it's in keeping with what judge after judge appointed by Republican and Democratic presidents have said about this acting attorney general.
Todd Blanche seems to have been living in some kind of fantasy world where he, as a lawyer, is all powerful and completely unrestrained because his hero, Donald Trump, feels all powerful and unrestrained. But it seems like he forgot about the Bar Association.
Well, I don't know that he's forgotten about it. And it may be like, as you mentioned, like Rudy Giuliani, where it comes back and hurts him. We are part of a profession and we do self-regulate, and we have seen it in action. I know for many people listening to it, that is, small recompense. That is not, absolute justice, but it is something that judges can do to make sure that lawyers adhere to their oaths of office. As somebody who served in the Department of Justice, I have to say it is particularly disappointing isn't the right term. It's really soul-crushing because you know that Todd Blanche knows better. And for whatever reason, whether it's power, fame, money, glory, whatever reason, he has been found over and over again by federal judges of all political persuasions, appointed by all sorts of presidents, have found his conduct to be in bad faith. What is remarkable is that he has a confirmation hearing coming up, and it really will be on Republican senators to say whether they're going to condone that kind of activity.
Andrew Weissmann, thank you very much for joining our coverage tonight.
You're welcome.
And coming up, the top Democrat on the House Judiciary Committee, which has jurisdiction over the Justice Department and Todd Blanche, Congressman Jamie Raskin, joins us next. Today, Judge Kathleen Williams cited this moment in Todd Blanche's unwise public testimony.
You and Associate Attorney General Woodward signed earlier documents regarding the settlement and this fund. Would both of you now sign and release documents reversing the DOJ's position on the fund?
We're not moving forward with the fund. I'm not sure what that means to sign documents reversing. There's nothing to reverse. We're not moving forward with the fund.
Judge Williams wrote, quote, "Acting Attorney General Blanche's decision, which has not been memorialized or adopted by plaintiffs or their lawyers, demonstrates his confidence that he could speak for and bind both sides of this matter. This certitude supports the conclusion that the parties worked in tandem and were never actually adverse." Joining us now is Congressman Jamie Raskin of Maryland, a constitutional law professor and the top Democrat on the House Judiciary Committee, which has jurisdiction over the Justice Department and Todd Blanche. Professor Raskin, let me first of all address you as a member of Congress, because what we just saw in that testimony is that you never really know when a congressional hearing is over. The event ends that day. There's a news cycle that covers material like that. But then down the line, weeks later, a federal judge uses it to basically close the case against Todd Blanche.
Yeah, look, the Department of Justice never did its job in this case, Lawrence. It's just so clear. There were numerous other plaintiffs who decided they wanted to sue the IRS because of the disclosures by Charles Littlejohn. And the DOJ every time aggressively went forward and they said, One, you can't sue us for what a third-party contractor does. That's very clear from the statute. And two, if you're outside of the statute of limitations, you're outside of the statute of limitations. Well, Donald Trump was way outside of the statute of limitations. It was very clear. And he also was just suing this third-party contractor. And then ridiculously, ludicrously, he sued for $10 billion when the statute limits damages to $1,000 for each act of disclosure. And they disclosed his taxes, so that's really $1,000. Even if you added up every fact in there, say there were 1,000, that would be $1 million, not $10 billion. So that's just fraudulent. But I agree with you. This is a very proud day for lawyers at a time when we have to be ashamed of people like Rudy Giuliani and Todd Blanche and Pam Bondi and Clarence Thomas and Justice Alito. I mean, we can really be proud of what this justice did and this soaring and just completely transparent and buttoned down opinion. And that's just a magnificent thing. Also, if you read some of the footnotes, like footnote 69, there are a lot of lawyers who participated on an amicus basis here, who we also can be proud of, like Don Verrilli, like Debevoise Plimpton. These are people who accepted appointment by the court to render various legal services and analysis. And then when they were told that Rule 11 sanctions were going to lie against the plaintiff's lawyers and they had the opportunity to get money, they said no. Unlike everything that's going on the other side of the ledger, well, that both sides of the ledger are Trump and Trump, where it's all about a money grab, these lawyers said no. And now the judge made the same offer to these 35 retired federal judges who also came forward to say this is a fraud on the court, that's going to be a fraud on the country. And the judges said they can petition for money if they want. It'll be interesting to see, but it's very clear none of these people have been motivated by money. They've been motivated by a true belief in the rule of law. And it reminds me of what's happened in some other societies like Pakistan and Poland and Brazil, where there have been authoritarian attacks on the government, on democracy and the rule of law. And the bench and the bar have stood up. And I think we're starting to see that happen all over America right now.
It also was a kind of reality moment for the crazy public comment that Donald Trump does as a litigant, along with the crazy and reckless public comment that Todd Blanche did in this case. All of their words that both Donald Trump and Todd Blanche have said about this could be and were used against them by the judge in this case.
Absolutely. And none of it, of course, was necessary because it was an absolute structural conflict of interest. And you just have to look at the record in the case. The judge points out that, for example, for 109 days in which this case was going on, there was never a notice of a lawyer filing on behalf of the Department of Justice. You know, I mean, it just didn't happen. And so it's all being driven by Trump. And by definition, this was Trump v. Trump. And you know who's going to win in a case like that? Trump is. And you know who's going to lose? The public is going to lose very clearly. And so that becomes clear as, you know, Judge Williams just peels the onion here and reveals what's really at stake. They sued for $10 billion, which was fraudulent and phony. The Department of Justice should have followed the advice of the IRS and just taken it down immediately. They didn't, unlike in every other case like it. And then they settled for $1.8 billion to go to Donald Trump so he could pass off some of it, at least, to the Proud Boys and the Oath Keepers and the insurrectionists. She didn't get around to mentioning that that in itself is unconstitutional under the 14th Amendment, which says that no taxpayer money can go for the purposes of insurrection or compensating insurrectionists. And the whole case was brought not to achieve a conclusion in the case, as the judge points out, but rather to achieve the settlement. And so it was a fraud on the court in order to perpetrate this fraud on the country, because who is it who really gets to appropriate money? The representatives of the people, Congress. And this whole thing was an end run around Congress and also an end run around the courts, because who decides real cases or controversies? The courts do. But as the judge found here, there was never a case or controversy at all. the whole thing was a setup and it was collusive litigation in order to create a collusive settlement. And the judge even forbade them from referring to this as a settlement. I assume they can refer to it as their fraudulent or their pretended settlement, but it's not to be referred to in court ever again as a settlement.
Congressman Jamie Raskin, thank you so much for joining us tonight.
My pleasure, Lawrence.
Thank you. And coming up, today's decision by Judge Williams highlights once again the important role the United States Senate has in confirming federal judges and what's at stake in which party controls the Senate. New polling now shows that Democrat Roy Cooper, running for Senate in North Carolina, is the most likely Democrat to take a Senate seat away from Republicans in the next election. Roy Cooper joins us next. The New York Times is reporting good news and bad news for the Democratic candidate for Senate in North Carolina, Roy Cooper. A recent New York Times poll shows Roy Cooper with a 7-point lead over Republican Michael Whatley, which is still within the margin of error. And there is this from the New York Times, quote, Roy Cooper, the Democratic former governor, entered April with $18.5 million in the bank. His Republican opponent, Michael Whatley, a former RNC chairman, had less than $2 million after accounting for debts. But thanks to a recent Supreme Court decision, Roy Cooper's fundraising advantage could disappear. The Times reports that before the Supreme Court decision, quote, a Republican super PAC would have to spend $50 million to $100 million to purchase the same amount of ad time that Mr. Cooper could buy with his funds. Now, Republican Party committees may qualify for the candidate rates for TV ads, offsetting Mr. Cooper's cash edge. Joining us now is former Governor Roy Cooper. He is the Democratic nominee for United States Senate in North Carolina. Thank you very much for joining us tonight. You know, I normally don't get into the campaign finance stuff in covering campaigns, but the rules got changed by the Supreme Court in the middle of your campaign.
Yeah, this is the worst campaign finance decision since Citizens United. It essentially allows candidates with the help of a party or a party organization to have unlimited spending. And Lawrence, that gives the advantage to the billionaires, the people who are already in power, and it takes the power away from these small donors. My opponent, Michael Whatley, the former chair of the RNC, already has those connections. He's been boasting about millions of dollars that he's now going to be able to unleash on us with his false attack ads. And I know that a poll that just came out today showed that this race was a little bit closer. I believe we're going to win because we're going to fight to make sure that people's paychecks keep up with the cost of living. But in North Carolina, we've only had 2 Democratic senators in almost 40 years. The last Democratic senator to be elected was 2008. So this is going to be a tight race all of the way. I want our small dollar donors to show the big money people that they can keep up with this. And we hope people will go to roycooper.com because everything you've outlined tonight shows why we have to take back a Senate majority. And we have to make sure that we flip North Carolina in order to get that done.
The polling on Donald Trump in North Carolina right now is 55% of likely voters in North Carolina disapprove of Donald Trump. And there's an 11% of Trump voters actually disapprove of Donald Trump. Can you reach those voters?
I believe we can because this administration promised that they would attack the cost of living issue on day one. Not only have they not done that, they've made it so much worse by snatching away people's health care, by putting on these chaotic tariffs that end up being paid by consumers and small businesses and farmers. And now with this war in Iran, gas prices are going up and diesel prices are going up, and people just simply can't make it. Stuff just costs too much. That's why I've been on my Make Stuff Cost Less tour throughout North Carolina. You can see our policy proposals at roycooper.com as well. We want to help people with childcare, with their health care, with their rent. All of these issues, utility bills, things that they are facing right now. I've never seen it like this. And another thing that's positive to me, Lawrence, is that I'm going all over North Carolina. We're holding these events. And at almost every event, someone comes up to me and says, this is the first political event I've ever been to in my life. And I know that's anecdotal, but I'm seeing it all over the state. I think people are recognizing that we need a course correction here, that these are not ordinary times, that things need to change. And I would ask everyone out there to think about what you can do to make sure we make these changes to make this country the kind of country we want to leave to our children and grandchildren. I'm excited about stepping up and doing this, but we know this is going to be a tough battle. This will be the toughest race I've ever had. I even ran against an incumbent Republican governor in North Carolina. That was a tough race. This one's going to be even tougher, particularly now that they have these new ways to bring money into the race. I'll be the first in line to overturn Citizens United when we can find a way to do that, because it's unconscionable the amount of money that's in these races right now. But we can't unilaterally disarm. We need people to step up and help us, and we need to take back this U.S. Senate.
Roy Cooper, thank you very much for joining us tonight. Roy Cooper gets tonight's last word.